Today we'll talk about a recent legislative decree which implemented in Italy the so-called e-privacy directive and data breach directive. So new rules regarding security of data in internet and in TLCs. Legislative Decree number 69 of last May 2012 issued by the Italian government and the relative guidelines issued by the Italian Data Protection Authority last July 2012 provide for new rules concerning data breach and which may occur to providers of publicly available electronic communication services. So to start, what is a data breach? A data breach means a security breach leading, accidentally or not, to destruction, loss, alteration, unauthorized access, disclosure of or access to personal data stored, transmitted in the provision of publicly available electronic communication services. Secondly, who does this regulation apply to? This regulation applies to publicly available electronic communication services, to providers of publicly available electronic communication services. This definition excludes all the subjects which provide services which do not consist wholly or mainly in the convenience of electronic signals regarding electronic communication. So, as confirmed by the Working Party, this regulation applies to phone service providers and internet access provider. Thirdly, what's the scope of these new provisions? The phone company, the phone services company and internet access provider will have to notify the Italian Data Protection Authority within 24 hours from the data breach, and within 3 days from the data breach will have to provide the Italian Data Protection Authority with a detailed report concerning the occurred data breach. Moreover, in worst cases, the phone service companies and internet access provider companies will have to notify also the subscribers or any other individuals adversely affected by the data breach. Moreover, providers shall maintain an inventory of personal data breaches comprising the facts surrounding the breach, the effects of those data breaches, and the remedial action taken. All these details are aimed to ensure that the Italian Data Protection Authority will be in the position to evaluate the compliance of the providers with the Italian law. The inventory shall all include the information necessary for this purpose. In the case of a data breach, if the Italian Data Protection Authority will be not notified, a sanction in the range between 25,000 and 150,000 euros may be payable. In case a subscriber or other individuals will be not notified, so in the worst cases, if the subscriber of the other individual will be not notified, a sanction between, in a range between 150 and 1,000 euros per single subscriber or other individual is provided. In any case, there is a limitation concerning the turnover of the involved company, the turnover of the last fiscal year closed. However, the sanction may be increased up to 4 times if the figure is deemed ineffective regarding the offender economic status. Finally, it is provided also another sanction regarding the lack of maintenance of the inventory. The sanction is in a range between 20,000 and 120,000 euros. These are the basic points of the new legislation regarding data breach in Italy. If you want to know more, please keep on follow our Lawyers Monday and search for me on LinkedIn.